Pet owners know all too well that cats and dogs are very different. These differences have even led to different liability standards, with many states enacting strict liability statutes for injuries inflicted by dogs, but not cats. Clark v. Brings explains what it takes to establish a cat owner's liability in Minnesota. Jeanette Clark was bitten, without warning, by Keith Brings' Siamese cat while babysitting his children. Clark sustained severe injuries and sued Brings and his wife for damages. At trial, Clark argued that a Minnesota statute holding dog owners strictly liable for personal injury should also apply to cat owners. In the alternative, Clark contended that Brings was liable under the common law scienter action because he knew the cat was dangerous. Under the scienter theory, Clark offered 3 pieces of evidence to prove Brings' knowledge of the cat's dangerous nature. First, a previous babysitter testified that the cat had lightly bitten her on the ankle after it became excited as she and the children dragged a string across the floor to make the cat chase. Second, the cat had previously scratched the Brings family members on their hands while playing. And third, Brings confined the cat to the basement. However, Brings testified that he did so to keep the cat from scratching the living room furniture, not because he feared it would attack anyone. Brings also presented evidence that the children had a toy room in the basement and often played with the cat there. At the close of evidence, the trial court directed a verdict in favor of Brings and denied Clark's motion for a new trial. Clark then appealed to the Minnesota Supreme Court.